Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only. It does not constitute professional legal, financial, or tax advice. Family law varies significantly by state and is subject to frequent changes. Every individual's circumstances are unique, and you should not rely on this content as a substitute for the counsel of a licensed attorney or a qualified professional in your jurisdiction. Please conduct your own due diligence and consult with a professional before making any decisions regarding legal proceedings. Imagine for a moment that it is 1924. You are trapped in a marriage that has become physically or emotionally untenable. In the eyes of the United States legal system, your desire for a fresh start is irrelevant. Unless you can prove beyond a shadow of a doubt that your spouse committed a heinous act, such as adultery, extreme physical cruelty, or total abandonment, you are legally bound for life. Fast forward to today, 2026, where a resident of California or New York can initiate a dissolution of marriage from a mobile device during a lunch break, citing nothing more than irreconcilable differences. We have transitioned from a society where divorce was a rare, scandalous legal battle requiring private investigators and staged photographs to a world where it is an administrative process as streamlined as filing a tax return. This shift did not happen by accident. It is the result of a 100-year tug-of-war between traditional moral frameworks and the individual's right to autonomy. In this deep-dive masterclass, we are peeling back the layers of the American divorce machine. We are going to explore how the divorce now process evolved from a clandestine, high-stakes game of legal theater into the multi-billion-dollar industry it is today. By the end of this series, you will understand the historical trends that shaped your current rights, the case studies that changed the face of family law, and the exact logistical hurdles you must navigate in the modern era. If you have ever wondered why some states have a 6-month waiting period while others have none, or why the concept of alimony is currently undergoing a massive legislative overhaul across the country, this is the blueprint you have been looking for. To understand the modern process, we must first look at the era of the fault-based regime, which dominated the American landscape for the first half of the 20th century. In the 1920s and 30s, divorce was not a choice. It was a remedy for a legal wrong. If both parties wanted to end the marriage, they actually faced a massive hurdle called collusion. If a judge suspected that a husband and wife had agreed to divorce, he could dismiss the case entirely, as the law viewed marriage as a permanent contract that only the state could dissolve upon proof of a breach. This led to what historians call the era of staged adultery. In New York, which had some of the strictest laws in the country, couples would hire professional actresses and photographers. The husband would go to a hotel room with the actress, they would pose for a photograph in a state of undress, and that photo would be presented in court as proof of a fault. It was a legal fiction that everyone, including the judges, often looked past, but it made the process expensive, humiliating, and reserved only for the wealthy or the desperate. This barrier created a massive market for what became known as the Reno Cure. Because family law is handled at the state level, Nevada saw a commercial opportunity. In 1931, Nevada lowered its residency requirement for divorce to just 6 weeks. This birthed the first iteration of the divorce now industry. Wealthy socialites from the East Coast would board trains to Reno, check into divorce ranches for 6 weeks, and wait out their residency requirement just to access a legal system that was more lenient than their home state. This created a two-tiered system of justice in America: those who could afford to travel for a quick exit, and those who were stuck in the rigid systems of their home states. When we look at potential outcomes for modern legislation, we see the echoes of this Reno period. Today's digital filing systems are simply the 21st century version of the Reno Ranch, removing the barrier of physical location to expedite a legal conclusion. The true turning point in this century of change occurred in 1969, when California Governor Ronald Reagan signed the Family Law Act. This was the birth of no-fault divorce. It fundamentally changed the question the court asked. The court no longer asked who is to blame. Instead, it asked, can this marriage be saved? If the answer was no, the divorce was granted. This legislative shift moved like wildfire across the United States. It recognized that forcing two people to stay together against their will was not only a violation of personal liberty, but also a source of significant social friction and domestic instability. Historical trends show that following the adoption of no-fault laws, there was a temporary spike in filings as decades of unhappy marriages were finally allowed to dissolve, followed by a stabilization of the rates we see today. However, the transition to no-fault did not mean the process became simple. It shifted the complexity from the why of the divorce to the how of the aftermath. This brings us to the modern divorce now infrastructure. In 2026, the process is defined by three main pillars: jurisdictional efficiency, digital disclosure, and alternative dispute resolution. Today, the administrative burden has moved from the courtroom to the cloud. Most states now utilize mandatory electronic filing systems where every financial document, from crypto wallet statements to retirement accounts, must be uploaded and verified through automated auditing software. The speed of the process today is often dictated not by a judge's schedule, but by how quickly parties can complete their mandatory financial disclosures. We are also seeing a massive rise in mediation and collaborative law. In the past, the only way to get a divorce now was to fight it out in a public forum. Today, case studies indicate that over 90% of divorces in the U.S. are settled out of court. The modern system is designed to incentivize settlement through the use of parenting coordinators and financial neutrals. This shift has turned the divorce process from a battle of narratives into a project of asset management and co-parenting logistics. For the contemporary viewer, this means that the divorce now process is less about winning and more about the efficient allocation of resources and the preservation of future stability. As we move through this 10-part masterclass, we will examine the specific mechanics of the current system, including the impact of the 2017 Tax Cuts and Jobs Act on alimony, the rise of birding and custody arrangements, and how artificial intelligence is now being used to predict asset division outcomes based on decades of case law. The problem many Americans face today isn't that they can't get a divorce. It's that they don't understand the high-speed machinery they are entering. The goal of this deep dive is to provide you with a comprehensive understanding of that machinery, allowing you to navigate it with clarity rather than confusion. We are moving from the dark ages of staged hotel photos into the era of transparent, data-driven dissolution. This is the evolution of the American family, and it is a story that is still being written. In the next part, we will break down the specific residency requirements and waiting periods that vary from state to state, explaining why your zip code is often the most important factor and how fast you can move forward. To understand why a divorce in Seattle looks nothing like a divorce in Miami, we have to look at the concept of jurisdictional sovereignty. In the United States, there is no federal divorce law. Instead, we have 50 different laboratories of legal experimentation, each with its own gatekeeping mechanisms known as residency requirements and waiting periods. These are the two primary throttles that the state uses to control the speed of a dissolution. If you are a resident of South Dakota, your timeline for a final decree is fundamentally different from someone living in Vermont. This creates a landscape where your physical location determines your legal velocity. Let us look at a case study from 2026 involving a character we will call David. David has lived in New York City for a decade. He and his spouse decide to part ways. In New York, the residency requirement generally dictates that at least one spouse must have lived in the state continuously for at least 2 years before filing, or 1 year if they were married in the state or lived there as a married couple. Now, imagine if David's job suddenly transfers him to Miami, Florida. If David moves to Florida and tries to file for divorce immediately, he will likely find the courthouse doors locked. Florida law typically requires at least 6 months of residency before you can even file a petition. This is the residency trap. David is in a legal limbo where he no longer meets the active residency threshold of his old state, but has not yet vested in his new state. Historical trends show that these laws were originally designed to prevent forum shopping, a practice where one spouse would move to a state with more favorable laws to gain an advantage in asset division or custody. In the modern 2026 landscape, residency is proved through digital footprints. Gone are the days of needing a neighbor to testify that they saw you at the mailbox for 6 months. Today, courts look at utility bills, voter registration databases, and even GPS data from mobile devices if residency is contested. If David tries to claim Florida residency while his primary bank transactions and cellular pings are still localized in Manhattan, the court can dismiss his case for lack of jurisdiction. This is a critical step in the divorce now process because filing in the wrong jurisdiction does not just delay the case. It can result in the total forfeiture of filing fees and the need to start the entire legal clock from zero. Once the residency hurdle is cleared, we encounter the cooling-off period, formerly known as the mandatory waiting period. This is the intentional friction built into the law to prevent impulsive decisions. In 2026, the variation across the U.S. is staggering. Take Texas as a case study. In Texas, there is a mandatory 60-day waiting period from the date the petition is filed until a judge can sign a final decree. This is often referred to as a cooling-off period, rooted in the historical belief that given a few months, a couple might reconcile. While 60 days might seem manageable, compare this to a state like Maryland. Historically, Maryland required a 12-month separation period for most no-fault divorces. Although laws have trended toward shortening these durations, some jurisdictions still maintain long wait times to ensure that the marriage is truly irretrievably broken. Now, imagine a contrasting scenario with a character named Sarah in Alaska. Alaska is often cited in legal case studies as one of the fastest jurisdictions for a consensual dissolution. If Sarah and her spouse have no minor children and have reached a full agreement on their assets, they can file for a summary dissolution. In some instances, the waiting period can be as short as 30 days, or even waived under specific statutory conditions. For Sarah, the divorce now process is an administrative sprint. For David in New York, it is a legal marathon. This disparity creates what legal scholars call the migratory divorce pressure. In 2026, we see potential outcomes where individuals intentionally choose their place of residence based on the efficiency of the local family court system. The logistics of the waiting period are also heavily influenced by the presence of minor children. In many states, the divorce now process is bifurcated. If you are a couple without children, the state views your marriage primarily as a financial contract that can be dissolved quickly. However, the moment a child is involved, the state's interest shifts to the doctrine of the best interests of the child. This often triggers longer waiting periods or mandatory parenting classes. For example, in states like Arizona or Illinois, parents may be required to complete a court-approved education program before a final decree is issued. Even if the parents are in total agreement, the clock does not stop until the certificate of completion is filed with the clerk. We must also consider the role of the 2026 digital infrastructure in these waiting periods. While the law might say you have to wait 90 days, the backlog of the local court system might turn that into 9 months. This is where the zip code factor becomes most apparent. In high population centers like Los Angeles or Cook County, Illinois, the sheer volume of cases creates a bottleneck. Even in a no-fault, uncontested scenario, the time it takes for a clerk to review the file and for a judge to sign the electronic order can add months to the statutory minimum. Conversely, in smaller, more automated rural counties, the process can be nearly instantaneous once the cooling-off period expires. There is a common misconception that if both parties agree, they can simply sign a paper and be done today. This is almost never the case due to the return of service requirements. Step by step, the process usually looks like this. The petitioner files the initial documents, then those documents must be legally served to the respondent. The respondent then has a statutory period, usually 20 to 30 days, to file an answer. Only after this window closes does the mandatory waiting period usually begin to count down. If the respondent is evasive or if they live in another state, the service of process can take weeks, effectively pushing the divorce now timeline further into the future. Furthermore, we are seeing a historical trend in 2026 where states are beginning to implement different speeds of divorce based on the complexity of the estate. Case studies in states that have adopted simplified divorce procedures show that if a couple has been married for less than 5 years, owns no real estate, and has less than a certain amount of debt, they can bypass the traditional courtroom experience entirely. This is the closest the U.S. has come to a true divorce now model, where the process is purely clerical. However, for the average American family with a mortgage, for 401(k) accounts and shared credit card debt, these shortcuts are rarely available. The deep dive into these jurisdictional variations reveals a harsh truth about the modern American legal system. Your rights are portable, but the process is not. If you are planning for a potential outcome that involves a quick dissolution, you are at the mercy of the legislative history of your specific state. You are navigating a system that was built over 100 years to be slow, deliberate, and sometimes intentionally difficult. The waiting period is not just a delay. It is a legal safeguard that the state uses to protect its own interests in ensuring that families do not become wards of the state due to hasty financial decisions. But what happens when the clock is ticking and the assets are moving? This brings us to the next layer of the masterclass. While you are waiting for that 60-day or 6-month timer to hit zero, your financial life is in a state of legal arrest. In many jurisdictions, the moment a divorce is filed, an automatic temporary restraining order, or ATRO, goes into effect. This order freezes the status quo. You cannot sell the house, you cannot change the beneficiaries on your life insurance, and you cannot move large sums of money out of shared accounts. As we move into the next phase of this deep dive, we have to talk about the money. because even if you live in a state with a 30-day waiting period, your divorce is not over until the math is done. In the next part, we are going to explore the high-stakes world of the 2026 financial disclosure. We will look at how the shift from paper records to digital asset tracking has changed the way property is divided, and why a single missing line on a disclosure form can cause a judge to vacate your entire divorce decree years after the fact. The process is fast, but the financial consequences are permanent. The moment the initial petition is served and the jurisdictional clock begins to tick, the legal system shifts its focus from the emotional state of the marriage to the forensic reality of the marital estate. In the Divorce Now landscape of 2026, we have moved past the era of digging through shoeboxes filled with faded receipts. We are now in the age of the financial autopsy. This is a high-stakes phase where every digital transaction, every fractional share of stock, and every automated subscription is scrutinized under a microscope. To understand the potential outcomes of your financial future, you must understand the two documents that form the backbone of the modern process: the schedule of assets and debts and the income and expense declaration. These are not merely forms, they are sworn statements made under penalty of perjury, and in the digital age, they are harder to manipulate than ever before. Imagine a character named James, a senior systems architect living in Seattle in 2026. James has been married for 15 years, and over the last decade, has quietly built a diversified portfolio of digital assets. He holds Bitcoin on a hardware wallet, has participated in several decentralized finance protocols, and even owns a few high-value digital collectibles. As his marriage begins to dissolve, James assumes that because these assets are decentralized and secured by private keys, they are outside the reach of the family court. This is a dangerous misconception that frequently leads to severe legal consequences. Historical trends show that as technology evolves, so do the tools used by forensic accountants and family law attorneys. In 2026, a standard subpoena to a fiat-to-crypto on-ramp, or a simple analysis of bank transfers can reveal the flow of marital funds into the digital ecosystem. If James fails to list these assets on his disclosure forms, he isn't just being savvy, he is committing a fraud upon the court. The consequences of non-disclosure in 2026 are swifter than they were even 5 years ago. In many jurisdictions, if a party is found to have intentionally hidden an asset, the court has the authority to award 100% of that specific asset to the other spouse as a sanction. This means that by trying to protect his Bitcoin, James risks losing the entirety of it. Case studies from the early 2020s paved the way for these aggressive sanctions, establishing a precedent that the duty of disclosure is absolute and ongoing. You cannot simply disclose what you have today. You must disclose what you had at the date of separation and explain any significant changes in the interim. Step by step, the disclosure process is a rigorous exercise in data aggregation. It begins with the identification of separate versus community property. This is where many individuals find themselves in a legal quagmire. Consider the scenario of Maria, who married her spouse in 2018. Before the wedding, Maria's grandmother left her $50,000 in a high-yield savings account. Throughout the marriage, Maria considered this her money. However, in 2022, she used $20,000 from that account to pay for a new roof on the family home, which was held in joint names. By doing so, Maria engaged in what is known as transmutation through commingling. In the eyes of the court in 2026, that $20,000 may have lost its separate property characterization and become a gift to the community. When Maria files her Divorce Now paperwork, she cannot simply claim the house is half hers and the savings account is all hers. She must engage in a process called tracing. This involves hiring a professional to look at every bank statement over the last 8 years to prove the source of the funds. In a deep dive masterclass context, it is vital to understand that the burden of proof always lies with the person claiming an asset is separate. While Maria and James are gathering their bank statements, they are also subject to the automatic temporary restraining orders, or ATROs, mentioned previously. In 2026, these orders are often integrated into the very summons you receive. They serve as a financial freeze frame. Imagine if James, feeling the pressure of the divorce, decided to change the beneficiary on his $1 million life insurance policy from his wife to his brother. Or perhaps Maria decided to sell the family's second car to a friend for $1 just to keep it out of the property division. Under the ATROs, these actions are legal violations. The court's goal is to maintain the status quo until a final judgment can be reached. Breaking these orders can result in contempt of court charges, fines, and a significant loss of credibility with the judge, which can negatively impact every other aspect of the case, from custody to the final division of the retirement accounts. The modern income and expense declaration is another area where the divorce now process has become incredibly precise. In the mid-20th century, a spouse might have claimed they spent $500 a month on groceries, and it was often taken at face value. In 2026, AI-driven software used by law firms can ingest 3 years of credit card and debit card data to produce an exact average of every spending category. If you claim your monthly expenses are $10,000, but the data shows you consistently spend $15,000, the court will notice the discrepancy. This document is the primary tool used to determine spousal support and child support. For the high-earning spouse, accuracy is essential to avoid overpayment. For the lower-earning spouse, it is essential to ensure their future needs are met based on the marital standard of living. Historical trends in the U.S. have shifted toward a more formulaic approach to support, often using software programs like Dissomaster or similar algorithmic tools. These programs take the gross income of both parties, their tax filing status, their health insurance premiums, and their mandatory retirement contributions to spit out a number. The divorce now process relies on these formulas because they provide predictability and reduce the need for lengthy, expensive trials. However, the potential outcomes are only as good as the data entered into the system. If you forget to include your annual bonus or the vesting schedule of your restricted stock units, the entire calculation is flawed. Furthermore, we must address the long-term integrity of the divorce decree. Many people believe that once the judge signs the paper, the financial book is closed forever. In 2026, this is not entirely true. Because the disclosure process is so central to the fairness of the deal, many states allow a spouse to move to set aside a judgment if they discover a material omission years later. Imagine if James successfully hid his digital assets, finished his divorce in 2026, and then in 2030, those assets skyrocketed in value. If his ex-spouse finds evidence of those accounts through a leaked database or a public blockchain audit, she can return to court and ask to vacate the entire financial portion of the divorce. The court can then redivide the assets based on their current value, often adding interest and legal fees as a penalty for the original deception. This brings us to a critical realization. The speed of the divorce now process is actually a double-edged sword. While the technology allows for rapid filing and automated calculations, it also creates a permanent, unalterable digital record of your financial disclosures. There is no room for error when the system is designed for total transparency. You are not just negotiating with your spouse. You are negotiating with a legal framework that prioritizes the equitable distribution of every cent earned during the marriage. But even after the assets are counted and the debts are assigned, there is one area of the divorce process that can never be fully automated, and that is the human element of custody. While we can use algorithms to calculate support and forensics to track Bitcoin, the way the U.S. legal system handles the time and well-being of children has undergone its own massive, often controversial transformation over the last century. In the next part, we are going to dive into the shift from the tender years doctrine to the modern 50-50 presumption. We will explore how 2026 parenting plans are being written to account for things that didn't exist 20 years ago, like virtual visitation and digital footprints for minors. How does the court decide who gets the kids when both parents work from home in a gig economy? The answer is more complex than you think. To understand the gravity of how we handle children in the 2026 Divorce Now process, we have to look back at the tender years doctrine, a legal principle that dominated the American landscape for nearly a century. Under this doctrine, the law assumed that during a child's formative years, typically under the age of 7, the mother was the only parent capable of providing the necessary emotional and physical care. This was a biological shortcut that the legal system used to simplify custody. If you were a father in the 1950s, your potential outcomes for custody were almost universally limited to every other weekend and perhaps a few weeks in the summer. However, the century of change has completely dismantled this framework. We have transitioned into the era of the best interests of the child standard, which has evolved further into the modern 50-50 presumption. Imagine a case study involving a character named Robert in 2026. Robert is a graphic designer who works entirely from his home in Austin, Texas. His spouse, Sarah, is an emergency room physician. In the 1980s, Sarah's traditional professional role, and the age-old bias toward maternal care, might have given her a significant advantage in a custody dispute. But in the 2026 Divorce Now landscape, the court starts with a blank slate. The primary question is no longer about gender or traditional roles. It is about the practical logistics of the child's daily life. Because Robert works from home, he argues that he is the parent best positioned to handle school pickups, sick days, and extracurricular activities. Sarah argues that her high-income status provides the child with a higher standard of living and educational opportunities. In the past, these two would have been locked in a scorched-earth legal battle. Today, historical trends show that the court is increasingly likely to look at the 50-50 model as the default starting point. The 50-50 presumption is a legislative movement that has swept through states like Florida, Kentucky, and Arizona. The logic is simple. The law now recognizes that a child's emotional stability is best served by having equal access to both parents. In 2026, the burden of proof has shifted. Instead of a father having to prove why he should have half the time, a parent who wants more than half the time must now prove why the other parent is unfit or why an equal split would be detrimental to the child. This shift has drastically changed the divorce now timeline. Because the outcome is more predictable, parents are less likely to spend 18 months fighting over a few extra days a month. However, the 2026 gig economy has introduced a new layer of complexity: the right of first refusal. Imagine if Robert, while working from home, gets called into a high-stakes 3-hour virtual meeting. Does he have to call Sarah to see if she can take the kids during those 3 hours before he calls a babysitter? In modern parenting plans, this is a specific negotiated clause. We are seeing case studies where parents are debating over windows as short as 4 hours. If a parent is unavailable for a set period, the other parent has the legal right to step in. This creates a highly fluid, data-driven custody schedule that would have been impossible to manage without 2026 technology. This brings us to the rise of birding or nesting. This is a concept that has gained massive traction in high-cost-of-living areas like San Francisco or New York. Imagine if, instead of the children moving between two houses, the children stay in the family home and the parents move in and out like rotating shifts. Robert stays in the house from Monday to Thursday, and Sarah takes over from Friday to Sunday. While the parents are out of the house, they stay in a smaller, shared apartment or with family. While this sounds like an ideal way to provide stability for the child in 2026, it is often a financial and logistical nightmare. It requires a level of communication and cooperation that many divorcing couples simply do not possess. The Divorce Now process in 2026 often uses nesting as a temporary bridge while the family home is being prepared for sale, but the potential outcomes often lead back to two separate households once the final decree is signed. We also have to address the digital footprint of the child. In 2026, a major point of contention in every parenting plan is the sharenting clause. We are seeing an explosion of litigation over what images and videos of a child can be posted on social media. Imagine if Sarah wants to post a video of their daughter's dance recital on TikTok, but Robert, concerned about digital privacy and facial recognition tracking, objects. Modern courts are now treating a child's digital identity as a protected asset. Many 2026 divorce settlements include strict prohibitions against using a child's likeness for commercial purposes or posting any identifiable information without the written consent of both parents. This is a far cry from the 20th century, where the primary concern was simply which parent got the physical photo albums. Virtual visitation is another 2026 staple. It is no longer just a courtesy, it is a court-ordered right. Even if Robert has the children for the week, Sarah likely has a legally mandated window every evening for a high-definition video call. The law now recognizes that physical distance is no longer a barrier to parental bonding. This has led to the rise of the move-away case. Historically, if a parent wanted to move across the country, it often meant the end of meaningful contact for the other parent. In 2026, judges are more inclined to allow moves if the relocating parent can demonstrate a robust virtual visitation plan, coupled with an aggressive summer and holiday schedule. To manage all of this, the 2026 legal system has moved away from email and text messages for parental communication. Courts now mandate the use of centralized parenting apps like Our Family Wizard or Talking Parents. Every message, every calendar change, and every reimbursement request is logged, time-stamped, and cannot be deleted. If Robert claims he told Sarah about a doctor's appointment and Sarah denies it, the judge doesn't have to guess who is lying. They simply log into the portal and look at the metadata. This level of transparency has shortened the Divorce Now process by eliminating the he said she said arguments that used to clog up the court calendar for months. But what happens when the 50-50 split doesn't work? What happens when the best interests of the child are genuinely at risk? This leads us to the most invasive part of the modern process, the 730 evaluation or the court-appointed special advocate. In 2026, these are not just social workers. They are forensic psychologists who use standardized testing and home observations to build a data-backed recommendation for the judge. They look at things like parental alienation, where one parent systematically undermines the child's relationship with the other. This is a high-stakes game. A negative evaluation can result in supervised visitation or a total loss of physical custody. As we look at the century of change, we see that we have moved from a system of rigid moral assumptions to a system of granular, individualized data. The divorce now process is no longer about assigning a winner and a loser in the parenting game. It is about creating a functioning business partnership where the primary product is a well-adjusted child. But this partnership requires a level of emotional intelligence that the legal system is still struggling to mandate. While the custody battle is the heart of the divorce, the skin of the process is the legal maneuverings that happen behind the scenes. Even with 50-50 custody and clear financial disclosures, there are ways that the process can be weaponized. In the next part, we are going to pull back the curtain on the world of high-conflict litigation tactics. We will explore how 2026 attorneys use temporary orders, emergency ex parte motions, and the strategic use of experts to gain leverage before a single permanent decision is made. How do you stay ahead in a system that is designed to be fair but is often played like a game of chess? The next phase of this masterclass is where the strategy gets intense. The first move in this legal chess match usually happens long before a judge ever sees the inside of a courtroom for a final trial. In the 2026 Divorce Now environment, the most critical phase is the period of temporary orders, known in many jurisdictions as pendant light orders. This Latin phrase translates to awaiting the litigation, and it represents the rules of engagement that will govern the family for the 12 to 24 months it might take to reach a final resolution. Many individuals make the mistake of thinking these orders are just placeholders. They assume that if they agree to a less than ideal support amount or a restrictive visitation schedule now, they can simply fix it later. Historical trends suggest the opposite. These temporary orders often create a new status quo that judges are extremely hesitant to disturb when it comes time for a final judgment. To understand the weight of this, imagine a character named Mark. Mark is a mid-level executive who moved out of the family home during the initial heat of the separation. He agreed to a temporary schedule where he only sees his children every other weekend because he wanted to keep the peace and avoid a fight. 6 months later, when he asks for a 50-50th split, the court looks at the current data. The children are adjusted, their school routine is set, and the current schedule is working. For Mark, the potential outcomes are now skewed against him. He has inadvertently demonstrated that the every other weekend arrangement is in the best interests of the children because it has become their new reality. This is the strategic trap of the temporary order. In the 2026 landscape, your first filing, the request for order, is often the most important document you will ever sign. It sets the baseline from which all future negotiations will flow. When the stakes are even higher, attorneys utilize the most aggressive tool in the Divorce Now arsenal, the emergency ex parte motion. This is a request for a court order made with little to no notice to the other party. In 2026, the standard for what constitutes an emergency is incredibly high, usually requiring a showing of irreparable harm or immediate danger. Imagine if Mark's spouse suddenly begins liquidating a joint brokerage account or threatens to take the children to a country that does not participate in the Hague Convention on International Child Abduction. Mark's attorney would file an ex parte application. Within 24 hours, a judge would review the declaration and could issue a temporary restraining order freezing all accounts or seizing the children's passports. This is high-velocity litigation. It is designed to stop the bleeding, but it also serves a secondary purpose. It establishes a narrative of high conflict and instability that can follow a party through the rest of the case. However, the 2026 legal system has also seen the rise of what is known as litigation exhaustion. Consider a case study involving a character named Elena. Elena is facing a spouse who has significant financial resources and is determined to use them to gain leverage. Her spouse's legal team begins a campaign of serial motions. They file a motion to compel discovery, followed by a motion to quash a subpoena Elena issued, followed by a motion for a vocational evaluation. Each of these filings requires a response, a hearing, and thousands of dollars in legal fees. This is the weaponization of the calendar. The goal is not necessarily to win each motion, but to drain Elena's retainer until she is forced to accept a settlement that is far below what she is entitled to. To counter this, the modern divorce now process includes specific legislative safeguards like Family Code 271 in California or similar fee-shifting statutes across the U.S. These laws allow a judge to sanction a party for conduct that frustrates the policy of the law to promote settlement and reduce the costs of litigation. If the court determines that Elena's spouse is filing frivolous motions just to run up her bill, the judge can order the spouse to pay Elena's attorney fees directly. In 2026, these sanctions have become a vital tool for maintaining a level playing field, but they require a clear, documented trail of the bad faith behavior, which is why the digital logs of all communications and filings are so essential. Beyond the attorneys, the modern chess game involves a roster of forensic experts. We have already discussed financial forensics, but the 2026 masterclass must also address the vocational evaluator. Imagine if Elena's spouse claims he can no longer work due to the stress of the divorce and therefore cannot pay support. Elena's team would hire a vocational expert. This expert doesn't just look at his resume. They analyze the current labor market data, his past earnings, and even his LinkedIn interactions to prove that he has the earning capacity to maintain his previous income level. The court can then impute income to him, meaning they will calculate support as if he were earning that money, even if he chooses to remain unemployed. This is a data-driven strike that removes the ability of a party to hide behind a sudden, convenient career crisis. Strategic maneuvering also extends into the realm of social media and digital discovery. In 2026, the first thing an aggressive litigation team does is archive the entire digital presence of the opposing party. They aren't looking for scandalous photos. They are looking for inconsistencies. If Mark claims in his financial disclosure that he is broke, but his spouse finds a geotagged photo of him at a luxury resort in the Maldives posted on a friend's private Instagram, that metadata becomes evidence. The legal team uses specialized software to crawl public and semi-private data, to build a timeline of spending and lifestyle that contradicts the sworn statements in the court file. In this era, privacy is a myth and digital footprints are permanent. The final stage of this tactical phase is the Mandatory Settlement Conference, or MSC. This is the last stop before a full-blown trial. In 2026, these conferences are often presided over by a temporary judge or a highly experienced family law mediator. This is where the chess game reaches its endgame. The parties are presented with the cold, hard data, the forensic accounting reports, the vocational evaluations, and the custody recommendations. The judge or mediator will often give a frank assessment of what is likely to happen if the case goes to trial. Case studies show that the vast majority of high-conflict cases settle at this stage because the cost of the trial, both financial and emotional, finally outweighs the potential gain of winning a few extra points on the asset split. But what if you don't want to play the game at all? What if you want to bypass the motions, the ex-parte hearings, and the forensic experts entirely? There is a parallel track in the American Divorce Now process that has seen a massive surge in popularity over the last decade. It is a path that prioritizes cooperation over conflict and privacy over the public record. It is called Alternative Dispute Resolution, or ADR, and it is changing the way the U.S. thinks about ending a marriage. However, ADR is not a simple fix. It requires a specific set of legal conditions and a high level of trust that many couples find difficult to reach. In the next part of this deep dive, we are going to explore the world of private judging and mediation. We will look at why the wealthiest families in the U.S. almost never step foot in a public courtroom, and how you can use their tactics to keep your private life out of the public database. We will break down the exact difference between a mediator and a collaborative lawyer, and why choosing the wrong one can lead to a total collapse of the negotiation. The courtroom is a battleground, but the mediation suite is a boardroom, and knowing how to navigate the latter can save you years of your life. To understand why alternative dispute resolution has captured the majority of the modern divorce now landscape, we must look at the structural decay of public court access over the last several decades. For a century, the public courtroom was the only venue for domestic dissolution. However, historical trends show that population growth, budget cuts, and a massive influx of civil and criminal cases have left public family law courts operating under severe resource constraints. In 2026, a family law judge in a major metropolitan area might have 40 cases on their morning calendar, leaving them with less than 10 minutes to allocate to complex human and financial decisions. This structural bottleneck has forced a massive cultural and legal pivot toward private dispute resolution, changing the divorce process from a public spectacle into a confidential business negotiation. Imagine a case study involving a character named Michael, a high-earning software executive in Los Angeles in 2026. Michael and his spouse have accumulated substantial marital property, including venture capital investments, equity options, and high-value real estate. If Michael takes his case through the traditional public court system, every financial disclosure, every line of cross-examination, and every toxic allegation becomes a matter of public record. Anyone, from a business competitor to a tabloid journalist, can pull the case file from the online clerk portal. For a prominent professional, this transparency represents a significant risk to their career and personal brand. To mitigate this, Michael's legal team looks toward a concept known as private judging. A private judge is a retired family law judge, or a highly experienced family law attorney whom both parties hire to preside over their case. Under the statutory frameworks of states like California and Texas, these private judges have the exact same legal authority as a sitting public judge. They can issue binding orders, sign final decrees, and rule on motions. The primary difference is operational infrastructure. Instead of waiting 6 months for a 10-minute slot in a crowded public courthouse, Michael and his spouse can book a full day in a private conference room within 48 hours. The private judge reviews the briefs thoroughly, the hearings are conducted in total privacy, and the scheduling is tailored to the needs of the family rather than the constraints of the state. While private judging maintains the adversarial structure of a trial, the absolute majority of modern 2026 cases utilize mediation, a process that relies entirely on consensus rather than coercion. Imagine if Michael and his spouse choose a collaborative path instead. They enter a mediation suite with a neutral third-party mediator, whose sole job is to facilitate an agreement. The mediator does not represent Michael, nor do they represent his spouse. They do not have the power to make decisions or issue orders. Instead, they act as a communication bridge, helping the parties identify common ground and draft a binding marital settlement agreement. Step by step, a high-retention mediation process in 2026 follows a highly disciplined path. It begins with the orientation phase, where the mediator establishes the rules of confidentiality. Under state evidence codes, everything said or produced during mediation is completely privileged. If the mediation fails, neither party can use the statements or settlement offers made in that room as leverage in a future trial. This creates a psychological safe zone where Michael can offer a creative financial trade-off without fear that his concession will be used against him later as an admission of weakness. The process then moves into the caucus phase, which is where the strategic engineering occurs. Instead of sitting across from each other at a massive boardroom table, Michael and his spouse are often placed in separate rooms. The mediator shuttles back and forth between them. In Michael's room, the mediator might reality test his positions, showing him the potential outcomes and costs of taking a specific asset dispute to a public trial. The mediator might say, "Michael, you are fighting over $100,000 in equity, but a trial will cost you $70,000 in expert fees and take a year of your life. Is that a rational allocation of your capital?" This objective feedback helps dismantle the emotional architecture that often keeps people trapped in litigation. A parallel trend in 2026 is collaborative divorce, which represents a distinct legal methodology. Many people confuse mediation with collaborative law, but they are fundamentally different machines. In mediation, you have one neutral professional and two parties who may or may not have their own independent lawyers. In a collaborative divorce, both Michael and his spouse hire separate, specially trained collaborative lawyers. Crucially, all parties sign a participation agreement that contains a disqualification clause. This clause states that if the collaborative process breaks down and either party decides to go to court, both collaborative lawyers are immediately disqualified from representing them. Both Michael and his spouse must fire their teams and start over with new litigation counsel. This disqualification clause completely shifts the incentives of the lawyers. In a traditional litigation model, a lawyer can theoretically make more money if the conflict escalates and goes to trial. In a collaborative model, the lawyer only succeeds if an agreement is reached. If the case heads to court, the lawyer loses the client and the fee stream. Case studies demonstrate that this structural incentive creates an environment focused entirely on problem solving. The collaborative team often expands to include a neutral financial professional and a child specialist, creating a multidisciplinary boardroom dedicated to dismantling the marriage with minimal collateral damage. However, alternative dispute resolution is not an automatic fix for every family. Potential outcomes depend entirely on two critical pillars: full financial transparency and balanced bargaining power. Imagine a scenario with a public character named Linda, whose spouse has controlled all the family finances for 20 years. If Linda enters mediation without an independent attorney or a forensic accountant, she is at a severe structural disadvantage. A mediator cannot force her spouse to disclose hidden assets, nor can they provide Linda with legal advice on whether a settlement offer is fair. If there is a history of domestic instability, coercive control, or severe financial asymmetry, mediation can become a venue for further manipulation rather than a fair negotiation. This is why the 2026 divorce now process increasingly relies on hybrid models like mediation arbitration, or MEDARB. In this scenario, the parties agree to mediate their issues first. If they hit an impasse on a specific item, such as the division of a specific retirement account or the summer custody schedule, the neutral professional instantly switches hats from a mediator to an arbitrator. They review the evidence, hear the arguments, and issue a binding arbitration award that is submitted to the court for a signature. This provides a definitive escape hatch, preventing the parties from getting stuck in an endless loop of unresolved negotiation. The efficiency of these private systems has turned the divorce now process into an exercise in project management. When you remove the theater of the courtroom, the case boils down to a sequence of decisions regarding asset valuation, cash flow optimization, and parenting logistics. But even the most successful mediation or collaborative process must ultimately interface with the state. The final marital settlement agreement must still be drafted into a formal legal judgment, reviewed by a court clerk, and signed by a public judge to officially dissolve the marital status. But what happens when the financial landscape itself undergoes a sudden seismic shift right in the middle of your negotiation? What happens when the traditional rules of asset valuation no longer apply because the global economy, the real estate market, or the tax code changes the value of your property overnight? This brings us to the next critical phase of our deep dive masterclass. Even if you have a private judge and a team of collaborative experts, you are still bound by the structural rules of valuation and taxation. In the next part, we are going to dive into the volatile world of asset valuation and the hidden tax traps of the modern divorce. We will explore why $1 million in a traditional 401k is not worth the same as $1 million in a Roth IRA, how the loss of the alimony tax deduction has completely changed the math of spousal support, and how to value a family business when the economy is in a state of flux. The boardroom negotiation is only as good as the math behind it, and in the next phase the math gets incredibly complex. To understand the raw mathematical architecture of a 2026 divorce, you must first discard the notion that a dollar is always worth a dollar. In the Divorce Now ecosystem, the intersection of asset valuation and federal tax policy creates a minefield wherein mathematically equal division of property on paper can lead to catastrophic financial outcomes in reality. Historical trends show that for decades, couples focused entirely on the face value of their accounts. If the husband took a $1 million retirement account and the wife took a $1 million primary residence, the split was deemed perfectly equitable. Today, that assumption is a dangerous legal relic. The modern tax framework treats different asset classes with radically different rules, making a deep dive understanding of tax liquidity absolute paramount to any modern settlement. Let us explore a case study involving a character named Christopher, a senior data scientist based in Denver, Colorado, in 2026. Christopher and his spouse have spent 12 years building their net worth. During their mediation sessions, they agree to split their two primary assets down the middle. Christopher takes the traditional 401k account, which holds exactly $800,000. His spouse takes their joint non-retirement brokerage account, which also holds exactly $800,000. On the surface, this is a clean 50-50 asset split. However, Christopher has just walked into a massive tax trap. The traditional 401k consists entirely of pre-tax dollars. When Christopher eventually reaches retirement age and begins withdrawing funds to cover his living expenses, every single dollar he pulls out will be taxed as ordinary income at his future tax bracket. If his effective tax rate is 25%, his $800,000 asset is actually only worth $600,000 in post-tax liquidity. Conversely, his spouse's non-retirement brokerage account consists of post-tax capital. While she will owe capital gains tax on the appreciation of the stocks within that account, the cost basis is completely different, and capital gains tax rates are historically much lower than ordinary income tax brackets. By failing to apply a tax discounting calculation to the retirement assets, Christopher has inadvertently accepted a significantly smaller share of the actual economic pie. To prevent these potential outcomes, the 2026 Divorce Now process utilizes a highly specialized legal mechanism known as the Qualified Domestic Relations Order, or QDRO. Step by step, a QDRO is a separate court order drafted after the final divorce decree that instructs a corporate retirement plan administrator to divide a pension or 401k account without triggering an immediate tax penalty or early withdrawal fee. Imagine if Christopher's legal team had used a QDRO to split both the pre-tax 401k and the post-tax brokerage account exactly in half. The plan administrator would create an alternate payee account for his spouse, moving $400,000 into her name. This maintains the tax-deferred status of the funds until retirement, balancing the future tax liability equally between both parties. The drafting of a QDRO requires extreme precision. If a single statutory phrase is omitted, the plan administrator can reject the order, forcing the parties back into court years after their status has been dissolved. Now, let us shift our focus to the real estate market of 2026, which introduces the complexity of the Internal Revenue Code Section 121 exclusion. Imagine a scenario with a character named Amanda, who owns a home in Austin, Texas with her spouse. The property was purchased years ago for $300,000 and is now valued at $900,000, representing $600,000 in taxable capital gains. Under current federal tax laws, a married couple filing jointly can exclude up to $500,000 of capital gains on the sale of their primary residence, provided they have lived in it for 2 of the last 5 years. However, if Amanda buys out her spouse's interest, takes sole ownership of the deed, and decides to sell the house 2 years down the road as a single filer, her capital gains exclusion drops instantly to $250,000. Amanda would find herself personally responsible for the taxes on the remaining $350,000 of appreciation. In a proper 2026 evaluation, her spouse's payout must be discounted to reflect this latent tax liability that sits beneath the home's equity like a financial ticking time bomb. The math becomes even more volatile when a family business or a closely held corporation enters the equation. Consider the case study of a character named Brandon, who founded a boutique logistics automation company during his marriage. The business has no public stock ticker, its cash flow fluctuates monthly, and its value is tied heavily to Brandon's personal industry relationships. In a 2026 divorce now proceeding, valuing this business requires a forensic battle between competing valuation methodologies: the asset approach, the market approach, and the income approach. Brandon's spouse hires an expert who utilizes the income approach, specifically a discounted cash flow analysis. They look at the company's projected earnings over the next decade and argue the business is worth $5 million. Brandon's expert counters with the market approach, looking at recent sales of comparable logistics companies in a high-interest rate environment, arguing the business is only worth $2 million. The true debate centers on a concept called enterprise goodwill versus personal goodwill. Enterprise goodwill is the value inherent in the business itself, its brand, its proprietary software, and its recurring customer contracts. This is a marital asset subject to division. Personal goodwill is the value derived solely from Brandon's individual reputation, skill, and personal relationships. If the clients only stay with the company because they like Brandon, that value cannot be transferred to a buyer, and under historical family law trends, personal goodwill is excluded from the property pool. Isolating these two numbers requires a granular audit of every client acquisition record and company asset, turning the valuation into a mathematical chess match. We must also analyze the tectonic shift in spousal support taxation caused by the Tax Cuts and Jobs Act, the effects of which are fully mature in 2026. For nearly a century, alimony was tax deductible for the person paying it and treated as taxable income for the person receiving it. This created a significant structural incentive during negotiations. The higher-earning spouse could offer a higher support payment because they knew it would lower their overall tax bracket, shifting the tax burden to the lower-earning spouse who sat in a much lower tax bracket. Today, for all divorce decrees entered after December 31, 2018, alimony is entirely non-deductible for the payer and tax-free for the recipient. This single legislative pivot completely altered the financial math of support. A payment of $4,000 a month under the old rules felt like less to the payer due to the write-off. Under the 2026 rules, $4,000 means a literal $4,000 out of the payer's post-tax pocket. Case studies reveal that this has compressed the average support awards across the United States. Payers are fighting harder against long-term support obligations, and courts are relying strictly on automated calculations to determine the precise net disposable income available to each household after federal, state, and local taxes are taken out. Every asset class has a hidden mathematical tax code attached to it. Stock options, restricted stock units, whole life insurance policies, and deferred compensation plans all carry unique liquidity profiles that cannot be ignored. The divorce now process is no longer just about deciding who gets what. It is an exercise in financial engineering, designed to ensure that both parties emerge from the dissolution with a clear understanding of their true net worth. But even when the assets are meticulously valued, the taxes are accounted for, and the support numbers are finalized, there is a human variable that can disrupt the entire structure. What happens when the underlying financial data itself is compromised by unexpected liabilities, or when a spouse discovers hidden financial debts right at the finish line? This brings us to the next vital phase of our masterclass: the execution of the final judgment and the mitigation of hidden debt liabilities. In the next part, we will explore the world of marital debt allocation, the impact of joint credit card liabilities, and how to protect your personal credit score when a former partner defaults on a court-ordered obligation. The division of wealth is only half the battle. The division of liability is where the real risk lies. To navigate the division of liability in the 2026 Divorce Now process, we must confront a fundamental disconnect between family law and consumer contract law. Many individuals believe that if a family court judge signs a decree stating that their ex-spouse is solely responsible for a specific debt, they are completely shielded from that liability. This is a catastrophic misconception. A family court judge has the authority to alter the legal obligations between two divorcing parties, but they do not have the power to alter a contract made with the third-party creditor. If your name remains on a joint credit card, a mortgage, or an auto loan, you are still fully responsible for that debt in the eyes of the bank. Historical trends show that debt allocation disputes are often the primary cause of post-divorce financial instability, turning what seemed like a clean break into a multi-year battle over credit scores and collection notices. Imagine a case study involving a character named Gregory, who lives in Phoenix, Arizona, in 2026. During his marriage, Gregory and his spouse opened a premium joint credit card to accumulate travel rewards. Over the years, the card balance grew to $30,000, driven by family vacations and household expenses. When they file for a divorce now dissolution, Gregory agrees to give up his claim to a shared savings account in exchange for his spouse taking full responsibility for the $30,000 credit card balance. The judge reviews the settlement, approves it, and writes the arrangement directly into the final divorce decree. Gregory believes he is free from this financial burden. 6 months later, Gregory attempts to secure a loan to purchase a new vehicle. He is shocked to discover that his loan application is rejected because his debt-to-income ratio is severely inflated and his credit score has dropped by over 100 points. His ex-spouse, facing an unexpected career transition, defaulted on the credit card payments. Because the original contract with the credit card company was signed by both parties, the bank does not care what the divorce decree says. They view Gregory as a delinquent co-debtor. They report the mispayments to the major credit bureaus, ruining his credit profile, and their collection department begins calling his personal phone line. For Gregory, the potential outcomes of this oversight are severe, illustrating why debt must be handled with extreme structural precision before the final paperwork is filed. Step by step, the modern method for insulating yourself from marital debt requires a process of total financial detachment. The first step is the immediate freezing and closure of all joint revolving credit lines. The moment a divorce petition is filed, attorneys often advise their clients to contact the creditors to convert the joint accounts into a restrict status, meaning no new charges can be made, while maintaining the payment schedule for the existing balance. If Gregory had taken this step, he would have prevented his spouse from running up further charges during the litigation window. The second step is the mandatory requirement of refinancing or debt consolidation as a condition of the final judgment. In a proper 2026 settlement agreement, Gregory's legal team would not have relied on a simple promise to pay. Instead, the decree would have mandated that his spouse must transfer the $30,000 balance onto a new, individual credit card or a personal consolidation loan solely in her name within 90 days of the dissolution. Crucially, the agreement must include an indemnification clause. This clause states that if the responsible party fails to refinance or pay the debt, and the creditor pursues the other party, the non-responsible party can return to family court to seek an immediate judgment for the full amount, plus attorney fees and damages to their credit worthiness. Now, let us examine an even higher stakes scenario involving a mortgage, utilizing a character named Kimberly in Atlanta, Georgia. Kimberly and her spouse purchased a home in 2020 with a historically low mortgage interest rate of 3%. In 2026, prevailing interest rates have shifted significantly higher. During their divorce now proceedings, the spouse wants to keep the house, and Kimberly agrees to a buyout of her share of the equity. However, the mortgage loan is in both of their names. If Kimberly simply signs an interspousal transfer deed or a quitclaim deed to remove her name from the property title, she is making a massive mistake. She has given up her ownership rights to the asset while remaining fully liable for the underlying mortgage debt. If her ex-spouse defaults on the mortgage, Kimberly's credit will be destroyed, and she could face foreclosure proceedings. The standard solution would be to force the spouse to refinance the home into an individual loan, but in the 2026 economic climate, refinancing means giving up that 3% interest rate and taking on a much higher rate, which the spouse may not be able to afford based on their single income. This is the mortgage lock-in trap. Case studies show that modern courts are increasingly forced to order the immediate sale of the family home because a refinance is financially unfeasible, destroying the plans of the parent who wished to stay in the neighborhood for the sake of the children. To manage this, some 2026 settlements utilize an assumption of liability, where the bank permits one spouse to take over the existing loan without changing the terms, though this requires strict underwriting approval that many banks are hesitant to grant. We must also analyze the hidden world of tax liabilities and the concept of the innocent spouse relief framework. Imagine if Kimberly's spouse ran a consulting business during the marriage and consistently underreported their business income on their joint federal tax returns to lower their annual tax burden. Years later, the Internal Revenue Service conducts an audit and issues a demand for $50,000 in back taxes, penalties, and interest. Because Kimberly signed those joint tax returns, the law holds her jointly and severally liable for the entire debt. The IRS can seize her personal bank accounts or place a lien on her current property, even if she had no direct involvement in the business. To protect individuals in this situation, the federal government offers specific relief mechanisms through the tax code. Kimberly would have to petition for innocent spouse relief, proving three distinct elements: that a joint return was filed, that there was an understatement of tax attributable to erroneous items of her spouse, and that when she signed the return, she did not know, and had no reason to know, that there was an understatement. In 2026, establishing this defense requires a thorough audit of past household expenditures to prove that Kimberly did not benefit from the unpaid taxes through an uncharacteristically lavish lifestyle. This process is slow, invasive, and highlights why the division of liability requires a deep understanding of federal regulatory frameworks. The modern landscape of debt also includes the rise of digital and micro-liabilities. In 2026, we see an explosion of disputes over buy now, pay later accounts, shared subscription balances, and digital device financing plans. While these amounts may seem minor compared to a mortgage, they are integrated into daily digital life. If an automated payment defaults on a shared phone plan, the carrier can cut off service to both parties instantly, disrupting employment and childcare communication. The 2026 Divorce Now process must treat these modern liabilities with the same level of granular detail as a commercial bankruptcy restructuring. The evolution of liability over the past century shows a trend toward total financial separation. The legal system has realized that a clean emotional break is impossible if the parties remain financially tethered through shared liabilities. The goal of a comprehensive masterclass is to show you that the true measure of a successful divorce is not just the size of the asset pool you walk away with, but the total elimination of any hidden financial trapdoors that could pull you back into court years later. But once the assets are divided, the taxes are calculated, and the liabilities are completely separated, you arrive at the absolute final hurdle of the modern machine: the administrative execution of the final judgment. Many people assume that when the judge signs the order, the process is instantly over and they are legally single. In reality, there is a distinct, often confusing procedural window between the signing of the decree and the legal termination of the marital status. In the next part, we are going to explore the final mechanics of the divorce decree execution. We will look at how states manage the formal restoration of former names, the updating of vital statistics databases, and the strict rules governing the formal date of termination. Why do some states make you wait 6 months after the final signature to remarry? And what happens to your health insurance coverage during this exact legal gap? The final steps of the masterclass are where the administrative details matter most. The signing of the final marital settlement agreement by both parties is a momentous milestone, but in the administrative machinery of the 2026 family law system, it is not the finish line. There is a distinct, often misunderstood procedural gap between the day a judge signs your judgment and the actual legal termination of your marital status. Many individuals operate under the false assumption that a signature equals instant freedom. In reality, you are entering a phase of administrative latency where the state processes the final dissolution, registers the change in vital statistics, and enforces statutory waiting periods before you are legally restored to the status of a single person. Understanding the exact logistics of this transitional window is essential to avoid accidental bigamy, sudden lapses in essential healthcare coverage, or compliance failures that could compromise your financial standing. To understand the critical nature of this gap, look at a case study involving a character named Charles, a logistics manager living in Columbus, Ohio, in 2026. Charles and his spouse successfully navigate an uncontested divorce now process. They resolve their asset split, their liabilities are separated, and the judge signs the final divorce decree on November 1st. Relieved and assuming the process is complete, Charles schedules a wedding ceremony with his new partner for November 15th. When he applies for a new marriage license, however, the county clerk rejects his application. Charles has run headfirst into a statutory remarriage restriction. Historical trends show that several states maintain strict waiting periods between the entry of a divorce decree and the legal right to remarry. In some jurisdictions, this restriction lasts for 30 days, 60 days, or even 6 months, designed originally to allow time for a potential appeal or reconciliation. For Charles, failing to verify the exact statutory termination date means his scheduled wedding is legally void, demonstrating that the calendar is dictated by state code, not personal preference. An even more urgent administrative hurdle during this legal gap is the immediate status of health insurance coverage. Imagine a scenario involving a character named Patricia, who has been covered under her spouse's corporate health insurance policy for 15 years. During the divorce now negotiations, her spouse agrees to keep Patricia on the family health plan until the end of the calendar year to allow her time to secure her own coverage. This agreement is written directly into the court-approved settlement. However, the moment the clerk processes the final judgment and the marital status is officially dissolved, a major structural problem arises. Under federal law and the explicit terms of almost all private insurance contracts, an ex-spouse is no longer considered an eligible dependent. The court order cannot force a private insurance company to violate its own contractual rules. The day the marriage is legally dissolved, Patricia's eligibility terminates automatically. If she goes to a medical appointment the following week, her claims will be denied, and she could face significant out-of-pocket expenses. This is the insurance gap trap. To prevent these potential outcomes, the 2026 administrative process relies on a federal framework known as COBRA, the Consolidated Omnibus Budget Reconciliation Act. Step by step, the dissolution of marriage qualifies as a life-changing event. Patricia's ex-spouse must notify the plan administrator within 60 days of the final judgment. The insurance company then issues a COBRA notice to Patricia, giving her the right to continue her existing coverage independently for up to 36 months. However, Patricia must pay the entire premium herself, including the portion previously subsidized by her spouse's employer. In a comprehensive 2026 settlement, the funds to cover these high COBRA premiums must be explicitly calculated and factored into the temporary spousal support modifications to ensure continuity of care. Beyond healthcare, the final execution of the decree involves the formal restoration of a former name. For many individuals, reclaiming their birth name is a vital psychological and practical step in the divorce now journey. In 2026, this is not an automatic process. If a party wishes to change their name, a specific request must be included in the initial petition or the final judgment paperwork. The judge's signature on the decree serves as the official court order granting the name change. However, the decree itself does not update the vast web of federal and state databases. The individual must take the certified copy of the divorce decree and manually navigate a sequence of administrative updates. The first stop is always the Social Security Administration. Until the federal Social Security database is updated, the State Department of Motor Vehicles cannot issue a new driver's license or state identification card, as their systems flag the name discrepancy for fraud prevention. Only after the Social Security card and driver's license are updated can the individual update their passports, banking institutions, and professional licensing boards, turning a simple name restoration into a multi-week bureaucratic project. We must also analyze the final updates made to vital statistics databases. When a divorce is finalized, the court clerk transmits a formal record of the dissolution to the State Department of Health or Bureau of Vital Statistics. This administrative step permanently updates the state's registry, closing the legal book on that specific marriage license. In 2026, this transfer of data is largely digital, but backlogs in state agencies can still result in delays. If an individual needs to prove they are divorced for immigration purposes, international business transactions, or to secure property financing, they cannot simply present a copy of the settlement agreement. They must obtain a certified copy of the final judgment with the clerk's official file stamp and signature. This administrative finalization also triggers the immediate need to restructure estate planning documents. The moment a divorce is finalized, historical trends in many states automatically revoke any provisions in a will or trust that leave assets to an ex-spouse or name them as an executor. However, relying on these automatic statutory revocations is a significant risk. If Charles finishes his divorce but fails to update the beneficiary designations on his employer-sponsored life insurance policy or his transferable on-death bank accounts, those assets may still pass directly to his ex-spouse upon his death. Federal retirement laws often preempt state family laws, meaning the name listed on the account card overrides the language in the divorce decree. The final phase of a true divorce now process is an exhaustive audit of every asset destination to ensure the post-divorce estate aligns with the new legal reality. The century of change has streamlined these final steps through electronic registration, but it has not eliminated the strict legal thresholds that govern the transition from married to single. You are navigating a bureaucracy that values absolute finality and systematic record-keeping above all else. Every box must be checked, every notice must be filed, and every statutory calendar day must count down to zero before you are truly unlinked from the state's marital grid. Now, you have seen the entire spectrum of the modern machine. You have seen how the history of fault gave way to no fault, how assets are uncovered through digital forensics, how custody is divided through analytical parenting apps, and how liabilities and administrative finalities are executed with mathematical precision. But this masterclass is not complete without looking at what lies directly ahead. The system we see today in 2026 is not static. It is actively evolving under the pressure of new economic forces, shifting cultural values, and emerging technologies that promise to reshape the family law landscape once again. In the final definitive part of this deep dive series, we are going to look into the future. We will explore the emerging trends that will define the next generation of the divorce now process. We will look at how artificial intelligence is moving from predictive asset auditing to drafting final judicial opinions, the legislative movements aiming to standardize custody across state lines permanently, and how the concept of marriage contracts themselves are changing to prevent the need for court intervention entirely. The future of family law is automated, decentralized, and faster than ever, and knowing what is coming next is the ultimate way to protect your autonomy. As we look beyond the landscape of 2026, the trajectory of the American family law system points toward a complete shift in how human relationships are unlinked. The past century was defined by the transition from fault to no fault, and then from paper bureaucracy to digital management. The next phase of this evolution is driven by automated decision-making and decentralized legal architecture. We are witnessing the emergence of predictive judicial analytics, algorithmic asset division, and a cultural movement that treats marriage not as a permanent status overseen by the state, but as a modular, time-bound civil contract. To fully grasp the potential outcomes of this shifting paradigm, we must analyze how these emerging technologies are moving from the fringes of legal tech straight into the mainstream statutory codes of the United States. Imagine a scenario in the near future involving a character named Thomas, an aerospace engineer living in legal limbo. In the traditional 2026 model, Thomas would have to hire a lawyer, file disclosures, and wait months for a court date or a mediation session to find out how his retirement accounts and real estate equity will be split. Now, imagine if Thomas and his spouse can log into a state-approved AI-driven judicial portal. The platform automatically aggregates their complete financial data through verified application programming interfaces linked directly to their banking institutions, investment portfolios, and tax records. Instead of an expensive legal battle, the system runs a predictive algorithm trained on millions of past family law judgments within his specific jurisdiction. The algorithm instantly generates a mathematically optimized property division proposal that represents the statistically most probable outcome if the case were to be litigated before a live judge. Case studies from early pilot programs in European jurisdictions and limited rollouts in some progressive U.S. counties indicate that when presented with a highly accurate, objective baseline, over 80% of couples choose to sign the automated agreement instantly rather than spend tens of thousands of dollars fighting over marginal variances. This is the future of the divorce now industry, the total outsourcing of negotiation to objective data pools. Step by step, the automation of family law is also fundamentally altering child custody logistics. We have already seen the widespread adoption of parenting apps to track communication, but the next generation of these tools goes much further. Imagine if Thomas's parenting plan is managed by an algorithmic scheduling assistant integrated with the school district's academic calendar, the parents' work schedules, and real-time transit data. If Thomas's flight is delayed or his spouse's work shifts change unexpectedly, the system doesn't rely on frantic text messages or emergency motions. The software automatically calculates the optimal adjustment to the physical custody schedule based on the preset parameters of their original decree, sends out automated notifications, and logs the variance for future support adjustments. This reduces the friction of co-parenting down to zero, removing the emotional triggers that historically dragged families back into the modification cycle for years. Furthermore, historical trends suggest that the concept of the permanent marriage contract itself is undergoing a legislative overhaul. For centuries, a marriage license was an open-ended commitment that required an active legal process to dissolve. Legal scholars are now projecting the rise of sunset marriage contracts, or term-limited marriages. Imagine if, when applying for a marriage license, a couple could opt for a contract that automatically expires after 7 or 10 years, unless both parties actively choose to file a digital renewal. If the contract expires without renewal, a pre-negotiated, automated unwinding protocol is triggered. The assets are divided according to preset parameters, custody arrangements revert to a default 50-50 framework, and the marriage dissolves with no need for a courtroom appearance, no filings fees, and no protracted litigation. This shifts the default state of the relationship from permanent attachment to intentional renewal, completely changing the societal framework of domestic stability. We must also look at the rise of decentralized ledger technology in family law. As smart contracts become more sophisticated, high-net-worth couples are beginning to bypass traditional prenuptial agreements in favor of digital escrow systems. Imagine if, instead of a paper document sitting in a safe deposit box, a couple's premarital assets are managed by a code-based protocol. The smart contract monitors the duration of the marriage and the allocation of marital funds in real time. If a separation event is initiated electronically by both parties, the smart contract automatically executes the pre-programmed distribution of digital and physical assets into individual wallets and accounts without requiring a third-party intermediary like a bank or a court clerk. While this level of automation presents significant challenges regarding regulatory compliance and consumer protection, the demand for privacy and speed is driving affluent individuals toward these self-executing legal structures. However, the automation of divorce also introduces a new set of ethical and systemic risks that the next generation of jurisprudence must address. Potential outcomes of a purely algorithmic system include the exacerbation of systemic biases and the elimination of judicial discretion. A computer program looks at the cold data. It cannot easily evaluate the nuance of a parent's emotional availability, the subtle signs of coercive control, or the unique psychological needs of a neurodivergent child. If the legal system relies too heavily on predictive models, it risks trapping individuals in a cycle of standardized justice that fails to account for the complex reality of human dynamics. The challenge of the next few decades will be finding the exact balance between the efficiency of automated processing and the necessary empathy of human oversight. The century of change we have documented in this 10-part masterclass shows that the divorce process is a mirror for American society. When the U.S. valued institutional permanence above individual happiness, the law created the rigid, punitive framework of the fault-based system. As the culture shifted toward individual autonomy and gender equality, the law adapted by introducing no-fault dissolution and the 50-50 parenting presumption. Now, as our society enters an era defined by data saturation, artificial intelligence, and digital efficiency, the family law machine is transforming into an automated administrative utility. Navigating this changing landscape requires more than just knowing what the law says today. It requires an understanding of where the system is heading tomorrow. By understanding the historical trends, the mathematical realities of asset valuation, the hidden traps of tax and debt liability, and the emerging tools of digital dispute resolution, you are no longer a passive participant in a confusing legal maze. You are an informed agent capable of managing your own legal velocity and protecting your long-term stability. The architecture of the American family will continue to evolve, but the core principle remains the same. Knowledge is the ultimate asset when the rules of the game are rewritten. As this chapter closes, a new frontier opens. While we have mastered the logistics of how a marriage ends, an entirely new structural revolution is taking place at the very beginning of the domestic life cycle. The way the modern legal system handles the formation of families, the changing definitions of legal parentage in the age of reproductive technology, and the rise of multi-party domestic